Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Risa Iris Ewonia, and today we are going to discuss how stool property can be managed. So what then is stool property or stool land? Stool land includes land which is controlled by any person for the benefit of the subject or members of the stool, clan, company or community, as the case may be. So stool lands are lands that the stool holds in their ownership and possession, and it is used for the benefit of the subjects of the stool. In respect of stool lands, it is the occupant of the stool that manages the land. So it is the chief who manages the stool land. But in the case where the chief is not available, the regent will then take the position of the chief to manage the land. In the management of stool lands, it's expected that issues will arise because whenever there is something that you manage for people, every day something must come up out of it. So in that instance, if the stool feels that certain actions have been taken against them, which is contrary to their rights on their land, it is the occupant of the stool that is supposed to institute the action in court. If the occupant is not there, the regent or the caretaker of the stool will institute that action. In the case of Gemfi versus Owusu, the court made it clear that it is only the occupant of the stool or the regent of that stool that can institute actions for and on behalf of the stool for the benefit of their subjects. Also, on another side, if a person feels that a stool has wrongly done an act that is affecting his rights, that person can only institute the action against the occupant of the stool. The case of Gemfi versus Owusu made it clear that it is only the occupant of the stool or the regent of the stool that can institute an action in court for the family, for the stool land. However, the case of Kwan versus Nyeni made very profound changes to the management of family land. And even though we are talking about stool land and its management, it's important to make mention of the case of Kwan versus Nyeni because that case has changed the law on the management of stool lands. In that case, the court reasoned that, yes, it is true that it is the head of the family that's supposed to institute an action in court in respect of family land. However, a member of the family can also bring the action in court under certain profound conditions which must exist. These conditions are that when the family property is in danger of being lost by the family and the head of the family, either out of his own personal interests or otherwise, is failing to act to protect it, the member of the family can bring the action in court. Also, where owing to the division in the family, the head of the family and some principal members of the family have refused to take certain pertinent steps which is necessary to protect the family land, the member of the family can institute the action. And when the member and principal, when the head of the family and principal members of the family are deliberately disposing of the family property for their own personal interest, the member can bring the action. But it must be one which is necessary, or it must be of a necessity. And that person must also have been appointed by other members of the family to bring the action. When this case was decided, many people were of the view that it should be extended to stool lands. There are certain instances where subjects of the stool may feel that the occupant of the stool is not taking certain necessary steps which will help protect their stool lands. Many people are of the view that it should not be extended to stool lands because those lands are very different from family lands. However, in the new Lands Act, Section 13 has extended these exceptions to stool lands as well. Section 13(2) of the Lands Act 2020 Act 1036 states that a chief, tendana, clan head, family head, or any other authority in charge of the management of stool or skin or clan or family land is a fiduciary charged with the obligation to discharge the management function for the benefit of the stool or skin or clan or family concerned and is accountable as a fiduciary. The key words to note in this provision is that the persons mentioned, who are the chief, tendanes, clan heads, family heads, and any other authority in charge of the management of these lands, are fiduciaries and they are accountable to their subjects as a fiduciary. A fiduciary relationship in law is a relationship based on confidence and trust. It's a relationship that you have with another person and you're expecting that that individual, based on the nature of the relationship you have with that person, will always take certain steps which will benefit you. And if the person cannot take those steps, the person must inform you of whatever decision they make, because those individuals are accountable to you. It is a relationship based on utmost good faith, and it must always be protected. Under Section 13(2) of the Lands Act, the chief and tendanes, who are the managers or occupants of these stool or skin lands, are in a fiduciary relationship with their subjects, and they are therefore accountable to them. So whatever decision that the occupant of the stool land or the skin land makes, they must always have their subject in mind, and they must always be accountable to them. Any money they make in their activities, they must account to their subjects, because it's important to know that occupants of the stool are not there for themselves, but they are there for the benefit of their subjects. On that note, Section 13 also makes it clear that fiduciaries must be transparent, and in their actions, they must be transparent, open, and fair, and impartial in any decision they make affecting those lands. And if those people, the occupants of the stool land, they fail to do that, a subject of that land can institute an action in court, but that person must have first exhausted the established customary procedure for making the occupants of the stool, skin, or the tendana render account. So this clearly shows that the Kwan versus Nyeni exception, which made it possible for members of families to bring an action in court in respect of family lands, has been extended to the management of stool lands. So now, subjects of the stool can bring an action in court to enforce their rights in respect of those stool lands. However, they must have first exhausted the established customary procedures for making the occupants of the stool accountable. And they must also have ensured that they have been granted leave by a court upon proof that a person qualified to institute the action has been informed of it for a period not less than 30 days before they brought the action. So before you bring the action, you must inform the occupants of the stool that these are the steps you are pursuing or you are intending to take in court. And the occupant must be aware of this, and the occupant must have failed to act. But you must also have exhausted all these established customary procedures under that stool before you can be qualified to bring the action in court. So now, in respect of stool lands, it is not only the occupants or the caretaker of the land that can institute an action. A subject can, but that subject must have established all the relevant procedures under Section 13 of the Lands Act before the person will be entitled to bring the action in court. In respect of stool lands, it is a very profound principle of law that it is the occupant of the stool and principal elders of that stool that can validly make a grant in respect of those lands. In the case of Alote versus Abrahams, the court made it clear that indeed the occupants of the stool and principal members or principal elders of that stool must make a grant to another person before that grant be valid. If the principal elders decide to act on their own accord without making reference to the occupants of the stool. The case of Aglo versus Sapo has highlighted that grant will be void because the occupants of the stool must always be present in such discussions so as not to prevent persons from acquiring lands, persons from thinking they have acquired lands when they have not even acquired lands. The principal elders of the stool do not have the right to make these transactions. It is not in their purview. The occupants of the stool must be present in these transactions for it to be valid. By way of a recap, in this video, I explained what stool land was, and I explained it to be land of the stool which was used for the benefit of the subjects of the stool. And I also highlighted that in respect of litigation, for the enforcement of the rights of the subjects in respect of the stool land, it is the occupant or the caretaker of the land that brings the action. But currently, under Section 13, subjects of the stool can bring action in court for the enforcement of their rights in respect of those lands, but certain conditions must be fulfilled. I also explained that when there's a grant to be made by the stool, it must be made by the occupants of the stool and some principal elders of the stool. If only the principal elders of the stool make that grant without the consent and concurrence of the occupants of the stool, that grant was invalid, or it was not a grant, it was void. Thank you for joining us in respect of the management of stool property. It was lovely having you here. Please do not forget to like, comment, subscribe, and share our videos to your friends so that they also know everything in respect of land law. My name is Risa, and this is the Law Lab. Thank you.